Now, a three-judge bench today in the High Court declared the Social Health Insurance Fund Act, the Digital Health Act, and the Community Health Promoters Act unconstitutional. Now, it was one key pillar of that judgment that both the National Assembly and the Senate failed to adhere to the prescription of the Constitution in terms of what the Constitution says a law should embody and what processes a law should be subjected to before it can be inserted into the public domain for enforcement. Primary of which was that the court took issue with the lack of any meaningful or substantive public participation that could be called uh, uh, public participation within the terms of the law. Now, the court castigated the haste with which both the Senate and the National Assembly executed the passing of these three pieces of legislation. And it was the concern of the court that there are many illiterate Kenyans, with respect, not being meant to anyone being illiterate, who could not access the website of the Ministry of Health in order to get the draft bills or the National Assembly or the platform offered by the Senate to get the digital format of these bills. And so the publication, which is essentially in hard copy, is done by the Kenya Gazette, the government printer by the Kenya Gazette. And the court questioned how any Kenyan could have accessed over a weekend such publications and be expected to then show up before the National Assembly or the Senate and give their views, considering especially that the Digital Health Act is framed in a very technical manner. And so the court said that all these were violations which go to the root of these three pieces of legislation. And even though the intention to have universal health care is a noble one and is one which is to be commended on the part of the government, you cannot override public participation because the governed must have their consent in terms of any law that will be used to govern them. And by reason of that, the High Court said that all those three pieces of legislation were unconstitutional. Beyond that, the court said that if you have to be forced to register under the Social Health Insurance Fund Act, and you're told that if you do not have that registration, then you're going to be denied any service by the county government, by the national government, and by all entities of the government at both national and county levels. That is going to deprive you of the access to emergency health care. For instance, if you are unconscious, and this is what the court in fact held, that if you go to a hospital and in that unconscious state, you need immediate medical attention. Your right to life is at stake. And your right to that emergency medical attention is again at stake. When the government says, hold it, you cannot have this access to this emergency treatment or ICU treatment because you're not registered under the SHIF and you do not have your up-to-date payments. The High Court ruled that that is unconstitutional, that is unlawful, and you cannot say that you are in compliance with the Constitution if you're forbidding people from accessing emergency health care under those circumstances. So in the end, the High Court has said that yes, you may have a noble objective to give every Kenyan the highest attainable health, but you cannot override their right to participate in the making of laws that engender or that give life to that objective. The High Court also ruled that it was wrong to call for a Senate sitting in Lodwar, and the public was not informed that this is actually supposed to be a participatory meeting for the public to collect their views about the Social Health Insurance Fund Act or the Community Workers Act or Health Community Workers Act, or the Digital Health. That was a regular court Senate sitting. It was not, as it were, uh, specifically tailored or called for as a public participation meeting. Now, in tandem with that, the court was castigating public officers who lie to the public that we are going to be having this form of a meeting to be able to achieve this when there is a predetermined decision about such an issue. It really is not, and it was not about public participation, and it was wrong. The High Court also said that it is important that the Commission for Revenue Allocation is involved in processes where the county has to expend money. And remembering that health is a devolved function. Health is a function, not the domain of the national government. It is the county governments that are tasked with ensuring the success of Article 43.1 to ensure that indeed, at the very basic level, every Kenyan has access to good health facilities. But what has been happening is the intrusion of the national government in a manner now that had happened through these three pieces of legislation without any form of involvement of the Commission for Revenue Allocation. And what was going to happen is that you have these three different funds. And one of the contentions that the petitioner had raised is that if you have these amorphous, very nebulous, and identified funds that Section 38 is naming of the Social Health Insurance Fund Act, and in the end, you have monies that are deposited there, and after every financial year, instead of returning any funds that are in excess of what the fund requires, it is retained by the fund. Then there is a loophole for theft of such public funds. The court said that that is impermissible, that that is wrong, and it was declared unconstitutional. In the end, the High Court has said that, look, you have a noble idea for the universal health care, but you cannot override the rights of Kenyans to participate in the process of lawmaking pertaining to that universal health care. And therefore, the High Court has said, you, National Assembly, you, the Senate, revisit these, start from square A. We have declared these acts unconstitutional. They are unenforceable as we speak. And although the Ministry of Health would like to say, we can enforce them, we have got a stay of execution, zero, you cannot enforce that which you cannot register anyone under. Both the High Court and the Court of Appeal had held that as long as they forbid registration of persons which is enforced, then you cannot speak of a healthcare system under the SHIF. Let's be clear about that. The Ministry of Health is holding on to these, clinging on to this idea that the Social Health Insurance Fund Act is still enforceable. It is not enforceable as long as you cannot register anyone. And if no Kenyan can be registered under the said act, you cannot talk of Social Health Insurance Fund Act being enforced.
Know that these laws exist. Actually, if the media did a survey, you'll find that very few people know about the veracity of this law and the impact to their own lives. We will also like to suggest that may the government resolve in future to make these bills also available in Swahili, because majority of Kenyans wanaongea Kiswahili. Sasa kuna ukuta mkubwa sana kati ya watu wa kawaida na wale wenye wanaweza kuongea Kizungu. Si wote ambao hawaongei Kizungu wako illiterate, lakini pengine hiyo ndio lugha wanaelewa. So hiyo ndio ninaomba ya kuwa iangaliwe such that haya mambo tunapanga kufanya na nchi ya kuwa yanajulikana na kila mtu. Jina langu ni Aura Joseph.